Hello, everyone. This is Lucas Morgan and Dae Lee with the most recent episode of Pharmacy Law Lowdown, sponsored by Drug Topics. We're here today to talk about some recent developments in the pharmacy benefit manager landscape, and namely the FTC settlement with Express Scripts, and also what might come down the road as it relates to the FTC settling with the other respondents currently involved in the FTC's action against the three largest pharmacy benefit managers in the country. So to kick things off, I'm joined by my colleague Dae Lee.
Thanks, Lucas. Nice to meet you all. Thanks for joining today.
So let's just circle back to the beginning of this subject matter. The FTC settlement, I would say in the legal world, knowing that, the old saying is that the wheels of justice turn slowly, it's hot off the presses. This settlement occurred in the very early part of February 2026. So, Dae, can you just give us a little bit of a high-level overview of what exactly we're talking about with this FTC settlement?
Yeah, I was very surprised to the settlement coming down the pipe. FTC has been looking into the vertical integration model created by pharmacy benefit managers, including Express Scripts, and how harmful impact that it created upon the pharmacy industry and patients. As we all know, 80% of the Americans' prescriptions are processed by or administered by top three PBMs, and those three are CVS Caremark, United Healthcare, Optum Rx, and Cigna Express Script. This settlement has a lot of key items that can improve the overall pharmacy industry, and there are spread pricing ban on it, rebate ban on it, and then there's also no differential pricing, and there's also a lot of meat on any willing provider law. So we want to unpack those during our session today.
Absolutely. So you've said a lot already. I want to always circle back to some of the basics here because there's terms that we throw around all the time, having worked in this space for a long, long time now. And the first one is we say it oftentimes as a three-letter acronym, PBM. We've already said the full name, Pharmacy Benefit Manager. But just at a very basic level for our listeners, can you just articulate briefly exactly what a pharmacy benefit manager is?
Sure. So they're literally the middleman between a pharmacy and the actual plan or plan sponsor who is providing prescription drug benefit to the patients. And as a PBM or middleman, ultimately what they do is they handle all claims between the pharmacy and the plan sponsor. And then whether they approve or deny a claim. So if you have a prescription and go to a pharmacy, and then there's either a pharmacy technician or pharmacist behind the computer typing in the patient demographic as well as the prescription that you just received. And then once that claim is submitted, or once the technician or pharmacist hits enter on the keyboard, that claim gets to the PBM, and then who will decide approve or deny. And PBM also determine the total dollar amount paid to the pharmacy, and then PBM will determine at the time of adjudication or at the time the claim was submitted by the pharmacy, determine patient's pay amount, whether it be copay, co-deductible or co-insurance. And also PBM, they negotiate so-called rebates with, pharmaceutical manufacturers. And of course, PBMs, they maintain their own network of pharmacies, whether it be their own or affiliated pharmacies versus the independent pharmacy networks that they maintain. So there's a lot of things that PBM does, but at the basic level, at the core level, PBM is the one who decides whether your prescription drug is covered under your insurance or not.
Yeah, and I think a term that we've hear often is this notion of being a middleman. And I often will say that, simply stated, the middleman position is that between an insurance company, or we'll often say a plan sponsor, and pharmacies. They're really serving as that liaison or conduit as between the health insurance company and the pharmacies. Certainly, there's a direct impact on patients as well. impacts how much is coming out of their pockets and how much they pay for their prescription medications. So I think a couple of things to point to, as you mentioned, Dae, I think we were both surprised when we saw this settlement come down. And there's a couple of reasons for that. And I think one of the big ones for me as an attorney that had been monitoring this, since its inception, is that it really survived and got to this point, because a lot of the work, the bulk of the work that was done on this investigation was done under an entirely different administration. And so it's very common that certain things that begin under one administration just lose steam, for the very simple reason that, you're having a changing of a lot of different personnel, a lot of different leadership. And it could often have nothing to do with a view on the actual underlying issues being investigated. It could just be a simple old losing momentum, among other things. Of course, there certainly could be other reasons, including political reasons, why something might lose its momentum. But this didn't. Initially, it looked like it was possible that it might, and that was because of the makeup of the commissioners that sit on the FTC and that were in charge of overseeing this investigation. But at the same time, I think when everyone thought this thing may lose all of its momentum, it really picked up steam. And fast forward to February, we have this first big announcement that there's a settlement between the FTC and Express Scripts. Now, to be clear, there are still 2 remaining respondents in the case. I should say there's more than 2 respondents, but the core respondents that we're talking about are Express Scripts, and that's who just settled with the FTC, and then also Caremark and OptumRx. We point those 3 out in particular because those are the 3 pharmacy benefit managers that make up the big 3, which Dae pointed out earlier, constitutes 80% of the prescription drug marketplace. It's a staggering figure. I often have to say it over and over again because a lot of people just immediately respond and say, isn't that a monopoly? Well, depending on your viewpoint, yes, but depending on others' viewpoint, no. I would just add that if you add in only 3 additional pharmacy benefit managers, you're covering 95% of the marketplace. And those additional 3 would be Humana Health Solutions, Prime Therapeutics, and also MedImpact. Those 6 combined cover 95% of the marketplace. So again, that's a staggering figure. I would say that it's likely that Caremark and OptumRx will eventually settle with the FTC. My source on that is we're continuing to hear some updates that the progress is being made between the FTC and Caremark and OptumRx. That's been represented jointly in statements and documents filed with the FTC seeking continuances and stays in the ongoing action. Currently, the matter is stayed until the end of March. It's possible we could see a settlement occur before that stay expires. We might also see an additional joint request for additional time to work on settlement. But let's set that to the side because we'll definitely keep an eye on that. And if and when a settlement comes down, that'll become the next episode of our podcast series with drug topics. But for now, let's dig into a little bit of the details in the actual settlement. And just for everyone so they know their knowledge, this is a public document. It's 15 pages long. You can get in there. You can read this, dig into the details. There's a lot there. Depending on your viewpoint, 15 pages may sound either really short or really long, but I will say there's a lot of detail here and a lot of interesting provisions. Now, from our perspective, representing a lot of different stakeholders, but especially a high number of independent pharmacies throughout the country, what are some of the provisions, Dae, that you saw in the settlement that you think are of particular relevance or import for independent pharmacies?
I think this applies to both independent pharmacies as well as patients, right? Everybody, I think deals with this dilemma, which is your premium goes up every year, and your out-of-pocket cost, copay goes up every year. I've been in this business many, many years, over a decade, close to 2 decades now, including my experience as a pharmacist. I've never met someone who told me my premium stayed the same or it actually went down. It's all because of the PBMs. The top 3 PBMs or the big 3 PBMs siphoning the market, creating this vertical integration. So one of the items that came from the settlement, which really is going to bring positive impact, upon independent pharmacy as well as a patient is um, prohibition of spread pricing. Okay, so spread pricing. What is spread pricing? So spread pricing is literally a spread that is arbitrarily created by PBMs when they actually invoice the plan sponsor, and when they or employers, or when they and then the actual reimbursement that they pay out to independent pharmacies. So let's say I'm a PBM. Okay. Unfortunately, for the sake of our conversation, let's say I'm Caremark or even Express Script. Spread happens when I bill the employer $1,000 for a given drug claim. Okay. And then the employer pays me $1,000. Am I going to pass that $1,000 to an independent pharmacy? The answer is no. I'll probably pay $100 to that pharmacy, hypothetically speaking. Okay. So what is the delta? $1,000 minus $100 is $900. That is the spread. And spread is in my pocket. That is my profit. Now, this FTC settlement got rid of that spread. It has to be 100% passed through. So what that's going to do is it's not only going to decrease the drug spend of employer, which will likely decrease the patient's premium as well as out-of-pocket costs, but also it's going to pass that money straight to the independent pharmacy. If it's 100, 200, whatever it is, there will be heightened level of transparency in the whole drug claim adjudication and then payment. So eventually, it will bring positive impact not only on the independent pharmacy but also on the patients.
That's really helpful to understand, Dae. And I also think, one of the things we want to do is unpack the settlement itself. Is spread pricing is a defined term in the settlement, but I think your discussion there provides a lot more context and understanding of exactly what it is. The definition in the settlement agreement says spread pricing means that a pharmacy spread exists between the amount paid to respondent by a plan sponsor for a drug product and the amount respondent pays to a pharmacy. To be clear, in this definition, respondent would be Express Scripts, or at least inclusive of Express Scripts. So it's saying there's a spread between the amount paid to Express Scripts as the PBM by a plan sponsor and the amount that Express Scripts pays to the pharmacy. So in Dae's illustration, that'd be $1,000 paid by the plan sponsor to Express Scripts for purposes of a particular drug product, and the work they do is the PBM. And then the PBM, in turn, separately and distinctly, reimburses a smaller amount to the pharmacy. The reason why I think this is so important is because for a very long time, there have been lots of different attempts to try and regulate and prevent spread pricing. But I think one of the biggest challenges that regulators had, and I would even say plan sponsors in many ways had if they were on the lookout for spread pricing, is they don't know what it is. Or they think they know what it is, but they don't know how to detect it if they're auditing or reviewing their claims or their contract with a PBM that they work with. I think even just having a definition of spread pricing in this agreement is helpful. Clearly, the FTC picked up on this as an issue from their investigation, because why else would it make its way into a binding settlement agreement like this? But again, I think at the bare minimum, the notoriety put on these types of issues in the settlement agreement is a great, great accomplishment and spells at least one reason for independent pharmacies and other stakeholders to be optimistic about the future. Now, another provision that was included in the settlement agreement relates to the notion of any willing pharmacy laws. So to kind of start off on that subject, I mean, is that important?
I mean, it is extremely important for pharmacies, and I think it's important that I mean is significantly important. And I would like you to explain why it's so important to independent pharmacies or other pharmacies that are not owned by PBMs in this country.
Yeah, well, I'm happy to explain that
Hmm.
one day. And the reason why I think that's so important is because independent pharmacies, there's just no doubt that the deck has always been stacked against them in this relationship. I'm not one that loves to play up kind of, the little guy versus the big guy or the David versus Goliath. But I do think at the end of the day, there's just no two ways about it. When it relates to the relationship between many, if not most, independent pharmacies and their relationship with pharmacy benefit managers, it is really the quintessential legal David and Goliath. Of course, the independent pharmacy being the David and the PBM being the Goliath. Any willing pharmacy law provisions, or oftentimes called any willing provider law provisions, have been one of the legal tools that's really helped to level the playing field as between independent pharmacies and pharmacy benefit managers. Now, I think this provision is uniquely interesting in the context of the settlement between Express Scripts and the FTC, even if we end up seeing this in the Caremark and Optum Rx settlement agreements. To be clear, I expect that we will. I will still absolutely celebrate that if that is included in the FTC settlements with the other PBMs. But the reason why I point this out in the context of Express Scripts is because Express Scripts has historically and consistently denied that there was any legal obligation on them to abide by any type of an any willing provider law provision or any willing pharmacy law provision. And my source on that is go to the United States Federal District Court for the Eastern District of Missouri, which is the venue provision for all lawsuits filed against Express Scripts regarding pharmacy disputes arising under the contract as between an independent pharmacy and PBMs. You can find court documents where Express Scripts puts in writing to judges, we don't have to follow an any willing provider law. There's a lot of different reasons they say that. One is they say the law doesn't apply to us. It applies to other third parties in this context, but it doesn't apply to us. There's other instances where they will also point out that any willing provider laws typically do not contain what's called a private right of action, which is another way of saying, even if we do have to follow this law, which again, we don't think that we do need to, even if we do, there's nothing they can do about it. And in this context, the they is independent pharmacies. They would say only the government can enforce this, but not independent pharmacies. This is a game changer. And just to read from this, to give a little sense and context of what it looks like, the provision from the settlement agreement under the provision identified as standard offering to retail community pharmacies says, respondent, and again, that's Express Scripts in this context, will not exclude any retail community pharmacy willing to agree to the terms and conditions for participation in respondent's standard offering to retail community pharmacies from participating in respondent's standard offering to retail community pharmacies. If we're going to break that down, it's basically if you have a retail community pharmacy that's willing to agree to your standard terms and conditions, then you have to let them in. It's a presumption in favor of admission into the network, not exclusion from the network. So this is very significant. The one thing I want to point out, though, is that this is a two-way street. It doesn't mean just unfettered access. And I do always want to reiterate, because even though we've often been, fighting on behalf of independent pharmacies, PBMs still do have certain legal obligations, and that's including to make sure that their network only allows qualified pharmacies to be in the network. Dae, can you just give a little bit of a overview of like the distinction between, a willing pharmacy that's qualified to be in the network and an example of where a PBM might be within its rights to exclude a provider?
Sure. I mean, pharmacies, presumably, they have to comply with the federal as well as the state law, and then they should not have any activity that suggests fraud, waste, and abuse activities. So as long as pharmacies don't have that kind of activities or suspicion of activities of false fraud, waste, and abuse, then they should be allowed. On the other hand, of course, there are pharmacies who and owners and even pharmacists who have tried to game the system and then submitted false claims or made financial commitments to third parties, including prescribers, to induce payments or induce referrals for prescriptions. Those should be excluded from the PBM network. So it's a little bit of black and white. I want to say there's no gray area. in terms of whether whether a pharmacy is a clean pharmacy to be enrolled in a network versus bad pharmacy that should be excluded. However, just because pharmacy made a mistake in the past does not mean that pharmacy um, should be terminated from PBM network indefinitely. And I think this law will definitely help independent pharmacies to gain footing, to get back into the certain Express Scripts network, or try to get into Express network for the first time.
That's really helpful. And so, again, that's kind of an overview of the any willing pharmacy law provision of the Express Scripts settlement agreement with the FTC. And I would just, remind our listeners that just keep in mind that we're talking about requirements at the federal level. Keep in mind that many states, and I would say right now, not all, but a majority of the states recognize some sort of a state-based corollary to the federal law requirements of any willing provider laws. So we would call those a state any willing provider law as a shorthand. But again, a very important provision in the settlement. I think the last thing I wanted to point out and just kind of get your perspective on, Dae, because I know that you do a lot of work at the plan sponsor level. You do a ton of work at looking at rebates and really understanding the intricacies of how rebate programs work. I know that you've engaged in very in-depth audits on behalf of plan sponsors, looking at their relationship, both contractual and otherwise, with PBMs, and trying to really unpack what all has actually happened as it relates to rebates and the flow of money in other respects. There's a lot of attention given in this settlement agreement to rebate conduct. One of the things that I wanted to just get your view on was this notion of reshoring rebate GPO functions and increasing rebate GPO transparency. Now, first of all, we'll often hear about GPOs or rebate GPOs. We've also heard the term rebate aggregator. Can you just briefly tell us what that is?
Yeah, they're one and the same. And, I use the term rebate aggregator. And in this case, Express Scripts owns rebate aggregator called Ascent Health Services, based out of Switzerland, not in the U.S. And Ascent's job is to negotiate with manufacturers and then get the most rebates from the manufacturers and supposedly pass that along to either Express Script or directly to the plan sponsor or employers. Now, why did they set it up? Why did Express Scripts set up Ascent Health Services in Switzerland? I don't know, but I could assume or I could presume that because they want to create another layer of opacity and then to make sure that U.S. law does not touch the Switzerland company. And to be clear, Ascent Health Services, they negotiate rebates with manufacturer for prescription drug claims paid in the U.S. Okay, so all these claims are paid by employers for employees in the U.S. And this Ascent Health is also another layer of the vertical integration created by Express Scripts. And when I represent employers or plan sponsors, 99% of times, they don't know whether a rebate aggregator was involved or even allowed to touch the claims that have been paid by the employer. So it's a great move by the FTC to force Express Scripts to relocate the Switzerland company into U.S. so that it's much easier to enforce U.S. law on the U.S. company versus the Switzerland company.
Yeah, and just to give this some real context in the context of the settlement with the FTC and Express Scripts, this provision says all activities, employees, functions, and assets used by Express Scripts, specifically respondent Ascent, that's the rebate aggregator for Express Scripts, for the purpose of rebate negotiating and contracting will be moved from Switzerland to the United States. So that's a clear order and requirement under this settlement that Ascent must be relocated from Switzerland to the United States. So that seems like a very significant provision to require them to basically pick up all operations in Switzerland and relocate to the United States.
Yes. And also, it might not be that much of heavy lift for Express Scripts because they may not have that many employees in Switzerland, you know, and handling those rebates for U.S. employers. And of course, vertical integration created by PBMs and also created including Express Script and these rebate aggregators, they are contributing to the ever increasing drug spend, ever increasing monthly premium, and the out of pocket cost. So, relocating the Ascent Health from Switzerland into US will have positive impact on all of those that we discussed today.
Yeah, and one point I just wanted to make real quick, because we've used this term a lot throughout today's episode, is what exactly vertical integration is. And just real brief high-level overview, I think we would say that, simply put, vertical integration is where one large corporation essentially owns, in some way, shape, or form, every layer of the relationship in the health insurance place. I will often use Caremark, which is, again, one of the respondents in the FTC case, because I think it's one of the easiest to illustrate with well-known names. But Caremark is actually a subsidiary of CVS Health, the parent corporation, which also owns several plan sponsors, names you're familiar with, like Aetna, SilverScript, so on and so forth. At the PBM level, they own the largest PBM in the country, or depending on the timing and how you measure, it's either Caremark or Express Scripts, but their pharmacy benefit manager that is owned in an affiliate of CVS Health is Caremark. They also own the largest retail chain pharmacy operations in the country, which is CVS Pharmacies. You see them all over the place. They also own very large, sophisticated mail order pharmacy operations, specialty pharmacy operations, and a whole host of other type of provider operations. So that's what we mean by vertical integration. They have a stake in every layer in every part of that chain of operations. So with that, I think to wrap up today's episode, this settlement between the FTC and Express Scripts is certainly a very positive development. We do expect there to be future developments as it relates to settlements with Caremark and OptumRx. We're going to certainly keep an eye on those. And as soon as we have more to report back on that, we'll certainly be updating you through this podcast and other means on that.